Antitrust claims against the nation's largest beef packers by a group of ranchers has been dismissed. A federal judge in Minnesota dismissed the claims filed by a putative class of cattle ranchers in a long-running case that alleged an industry-wide scheme to fix prices. Drovers reports that the U.S. District Court for the District of Minnesota ruled the plaintiffs lacked standing to pursue their central arguments. The suit alleged the largest beef packers, JBS, Tyson, Cargill, and National Beef Packing, conspired in an industry-wide scheme to widen the meat margins between the cost of live cattle and price of processed beef. Further, the packers were accused of forcing the cost of cattle down and the price of beef higher through cartel tactics like coordinated procurement and slaughter restraint. The lawsuit alleged the four packers violated the Sherman Antitrust Act of 1890 by engaging in a price-fixing conspiracy, and that they violated the Packers and Stockyards Act as well as the Commodity Exchange Act. In his decision, the judge said there are too many stages in the beef supply chain and too much time between the rancher's sale of live cattle and their purchase by meat packers to adequately establish standing for the Sherman Act and the Packers and Stockyards claims. But members of the lawsuit still are seeing red flags, they say. Back in September of last year, JBS reached a $52.5 million class action settlement with beef wholesalers. And just 3 weeks ago, Smithfield announced their third agreement, a $75 million pact, paying off consumers in a settlement case.
Why beef? Because it sustains my family's sixth generation family ranch, America, and a good chunk of the world.
On Monday, 171 members of Congress signed a letter opposing the inclusion of the Ending Agricultural Trade Suppression, or EATS Act, in the 2023 Farm Bill. The EATS Act would prevent legislation like California's Proposition 12, which prohibits the sale of pork in California from hogs not raised in the production standards adopted by the state. In the letter sent to House Agriculture Committee Chair G.T. Thompson, the members of Congress said Prop 12 is not a case of California imposing its standards on other states, writing producers in any state can choose not to supply another state's consumer or to segregate animals for different markets. At the end of June, the Superior Court for the County of Sacramento issued an order further modifying certain aspects of the implementation schedule for California Prop 12. The order effectively provides an extension of time for the continued sale of non-compliant whole pork meat already in the supply chain when Proposition 12 takes effect. The order does not delay the underlying requirements of Prop 12, though.